I emptied their trash cans for 3 straight years. Then I emptied something they cared about a whole lot more, their bank account. Funny thing is, when people hear that part, they assume I spent those 3 years planning some elaborate revenge. I didn't. I spent those 3 years watching people make the same mistake over and over again. They looked at the mop in my hand and decided that was the only thing I'd ever held. My name is Daniel Mercer, and before anyone ever handed me a janitor's key ring, I spent almost 16 years as a corporate litigation attorney in downtown Minneapolis. I knew contracts better than most people know their own families. But life has a strange way of knocking the wind out of you. My wife passed away after a long fight with cancer. My father suffered a stroke 6 months later. And somewhere between hospital waiting rooms and funeral homes, I realized I didn't have another courtroom battle left in me. I walked away from the law before it destroyed what little peace I still had. People always assume that if a lawyer ends up cleaning office buildings, he must have lost everything. The truth is, sometimes you don't lose your career. You simply stop wanting the life that came with it. Working nights as a janitor paid the bills. Let me take care of my dad during the day. And, surprisingly enough, gave me something I'd forgotten lawyers rarely have: silence. At least that's how it started. The company I worked for, Weston Dynamics, occupied 12 floors inside a sleek glass tower overlooking the river. They made software for logistics companies, bragged about being a family, filled every hallway with motivational posters about integrity and respect. Every Monday morning, executives stood in the lobby shaking hands whenever television cameras showed up. And every Tuesday night, I quietly emptied the coffee cups they'd left sitting on conference room tables after another meeting about company culture. You notice things when nobody thinks you're listening. You hear conversations through half-open doors. You see documents tossed into recycling bins because someone assumes the cleaning crew can't read them. Most people become invisible once they put on a maintenance uniform. I learned to embrace that invisibility. 3 years passed without much excitement. The accountants knew my first name. Security guards saved me leftover donuts from overnight shifts. One engineer named Luis always stopped to ask how my father was doing. Little moments like that reminded me decent people still existed. Unfortunately, they weren't the ones making decisions. Everything changed on a rainy Tuesday morning in October. I walked into the maintenance locker expecting another ordinary shift. Instead, an envelope sat on my shelf with my employee number written across the front. Inside was a termination notice. No meeting, no warning. Just a single paragraph informing me that my position had been eliminated as part of restructuring. At the bottom sat one sentence that hit harder than losing the job itself. Retirement incentive forfeited. $47,000. Gone. I must have read that line 10 times because my brain refused to accept it. 3 years of staying late, covering extra shifts, missing holidays with my family, erased with 12 typed words. I carried the letter upstairs to Human Resources before I even realized my feet were moving. Waiting inside the conference room were Human Resources Director Melissa Grant and Executive Vice President Richard Holloway, a man who somehow managed to smile without showing any warmth. He leaned back in his chair while Melissa slid a stack of papers toward me. "Sign this separation agreement today," she said calmly, "and we'll process everything quickly." I looked down. Standard release. Waiver of claims. Confidentiality. Non-disparagement. It was familiar territory. Too familiar. I asked one simple question. "Where's my retirement bonus?" Richard actually laughed. Not loudly. Just enough to let me know he enjoyed what came next. "Daniel," he said, folding his hands together, "you're a janitor. You really don't get to question how executive compensation decisions are made. There are moments in life when the room seems to shrink around you." My first instinct wasn't anger. It was disappointment. Not because they'd fired me. Companies do that every day. But because after 3 years they genuinely believed they knew who I was. Melissa tapped the paperwork with her pen. "Sign today or you leave with nothing." I looked at both of them for a few seconds longer than was probably comfortable, folded the termination letter, slipped it into my jacket pocket, and quietly stood up. Richard smirked as I reached the door. "Good luck finding another janitor position at your age." I almost smiled back because he had unknowingly answered the one question I'd been asking myself since opening that envelope. They truly believed I had nowhere else to go. That afternoon, I drove home, made coffee, checked on my father, then walked into the spare bedroom that had slowly turned into a storage room over the years. In the back of the closet sat an old leather briefcase covered in dust. I hadn't opened it in over 3 years. Inside rested my law license, still active, my framed admission certificate, faded trial notebooks filled with handwritten arguments, and business cards from a version of myself I'd almost forgotten existed. I picked up my bar card, turned it over in my hands, and laughed quietly. Not because revenge suddenly sounded exciting, but because I realized something Richard Holloway never had. He thought he had fired a janitor. What he had actually done was wake up an attorney who had spent 3 years studying his company from the inside, without anyone ever thinking he understood exactly what he was seeing. And before the sun came up the next morning, I'd already started writing the complaint that would change every one of our lives. The complaint practically wrote itself, but that wasn't because the case was easy. It was because I had spent 3 years collecting memories without realizing they would eventually become evidence. Every late-night conversation I'd overheard while replacing trash liners, every policy binder left open in conference rooms, every careless comment executives made when they thought only the cleaning staff was around suddenly fit together like pieces of a puzzle. Wrongful termination, breach of contract, unpaid retirement incentive, wage violations, intentional infliction of emotional distress. I wasn't throwing accusations at the wall hoping something would stick. Every claim had a foundation, and after 16 years in corporate litigation, I knew better than to walk into court carrying emotion instead of facts. Thursday morning, I filed everything in Hennepin County District Court before most people at Weston Dynamics had finished their first cup of coffee. By lunchtime, someone inside the company had obviously received notice because my phone lit up with an unfamiliar number. It was Melissa. Her voice sounded completely different from the one I'd heard 24 hours earlier. Softer, almost friendly. "Daniel," she said, "I'm sure we can work this out without making things public." I smiled to myself. Yesterday, I was just a janitor. Today, I was suddenly Daniel again. "I'm sure we can," I replied, "through the legal process." Then I hung up before she could answer. Monday morning, their attorneys filed a motion to dismiss. That didn't surprise me. Big companies always try to end cases before discovery because discovery is expensive, unpredictable, and dangerous when executives have spent years believing their emails are private forever. What did surprise them happened during the first hearing. Their lead attorney, a polished partner from one of Minneapolis's largest law firms, confidently argued that my employment agreement required binding arbitration. He spoke for nearly 15 minutes about jurisdiction, procedural requirements, and contractual obligations. I sat quietly taking notes. When the judge finally looked at me, she asked, "Mr. Valles, Mercer, your response?" I walked to the podium carrying only one folder. "Your Honor," I said, "opposing counsel is relying on the wrong employment agreement." The courtroom became very still. I handed copies of my actual contract to the clerk. White-collar employees signed version B. Maintenance staff signed version A. Version A contains no arbitration provision whatsoever. The judge compared both documents side by side, looked back toward their attorney, then asked one simple question. "Counsel, did anyone verify which agreement your client actually used?" He flipped through his own binder with growing panic while someone behind him whispered frantically. I already knew the answer because I'd confirmed it before accepting the janitor position years earlier. I had specifically chosen not to sign away my right to sue. The judge denied their motion before lunch. As we walked out, I caught Richard Holloway glaring at me across the hallway. For the first time since I'd known him, he looked uncertain. Discovery officially opened that afternoon, and that's when their real problems began. Most people think lawsuits are won through dramatic speeches in court. They aren't. They're won through paperwork. Endless, exhausting paperwork. I requested personnel files, internal bonus policies, executive emails, compensation committee notes, retention incentive records, termination statistics, communications regarding restructuring, audit reports, deleted document recovery logs, and every policy revision from the previous 5 years. Their legal team objected to almost everything. I expected that. I filed motions to compel. The court granted most of them. Suddenly, dozens of employees were spending their workdays collecting documents instead of running the business. Their attorneys billed by the hour. Their IT consultants billed by the hour. Their electronic discovery vendor billed by the gigabyte. Every delay they created simply increased their own expenses. Mine remained exactly the same. 0. I represented myself. During those weeks, I settled into a strange routine. Every morning, I'd help my father with breakfast, drive him to physical therapy twice a week, then spend afternoons reviewing production files at my kitchen table. Some evenings, I'd stop by a diner a few blocks away where the waitress, Nancy, had known me since my lawyer days. One night she asked whether I regretted filing the lawsuit. I thought about that while stirring my coffee. No, I finally answered. I regret that they assumed someone wearing work boots wouldn't know how to defend himself. She nodded without saying another word. Around day 10, something interesting happened. Luis, the engineer who always asked about my father, called me after work. He sounded nervous. Daniel, I probably shouldn't be doing this, but people are scared. We met at a public park instead of a restaurant. He told me morale inside Weston Dynamics had collapsed. Managers were ordering employees not to discuss my lawsuit. HR representatives had begun reminding everyone about confidentiality obligations. Rumors spread that executives were deleting emails. I thanked him for the information, but told him not to risk his own job for me. Before leaving, he looked back and quietly said, "You know, a lot of people are rooting for you." That sentence stayed with me longer than I expected. Around the second week, document production accelerated because the judge had grown impatient with delays. Thousands of pages arrived electronically. Most of them were exactly what you'd expect: organizational charts, policy manuals, payroll summaries, committee minutes. Boring. Necessary. Then, sometime after midnight one Thursday, I opened a folder labeled Executive Compensation Review. Buried inside a chain of emails was something that made me stop breathing for a second. One vice president had written, "If we deny retirement incentives after restructuring, hourly employees rarely challenge the decision. Most can't afford litigation." Another executive replied, "Agreed. Historically, less than 3% pursue legal remedies." This wasn't an isolated mistake. They had calculated the odds. They were gambling that ordinary workers would simply walk away. I kept reading. More emails appeared. Different departments. Different years. Different employees. 17 names. Warehouse staff. Maintenance technicians. Shipping clerks. Security personnel. One after another. Retirement incentives disappeared following layoffs or reorganizations. Every file contained slightly different wording, but the pattern never changed. Delay, deny, pressure them into signing release agreements. I leaned back in my chair and stared at the ceiling for a long time. The case had just become much larger than $47,000. 2 days later, another unexpected piece fell into place. While organizing old maintenance schedules I'd saved for tax purposes, I remembered something from my janitor days. Executives almost never shredded sensitive drafts themselves. They tossed them into designated confidential disposal bins that were collected every Friday. One evening months earlier, one of those bins had overflowed after an audit meeting. Several documents had spilled onto the floor before I picked them up and returned them. At the time, one page caught my attention because it mentioned incentive liabilities. I hadn't stolen it. I simply remembered the wording. That memory helped me search the discovery production using specific phrases. Eventually, I found the complete document. It outlined projected savings from eliminating retirement obligations during workforce reductions. They had literally budgeted for breaking promises. Mediation was scheduled for day 18. We met in a neutral office building downtown. Their legal team occupied one conference room while I sat alone in another, with nothing more than a legal pad and a bottle of water. The mediator spent most of the morning carrying offers back and forth. $25,000? I declined. $50,000. I declined again. 75. Still no. Around lunchtime, Richard finally walked into my room himself. He hadn't expected to see me without an attorney. He looked around almost disappointed. "You're making a mistake," he said. "Litigation is expensive." I couldn't help smiling. "For who?" His expression hardened. "You could walk away today with more money than you ever expected." I slid a neatly organized binder across the table. "Before I answer, I'd like you to read tabs 4 through 12. He opened the binder casually. 30 seconds later, the color drained from his face. Every highlighted email, every executive response, every discussion about targeting hourly workers because they lacked resources. He slowly closed the binder and whispered, almost to himself, "Where did you get all this?" "Discovery," I answered. "The process your lawyers tried so hard to avoid." When he walked back into the other conference room, the mediator gave me a strange look. "I've been doing this for 22 years, he said quietly, "and I've never seen someone's confidence disappear that fast." The mediation ended without settlement, but I knew something had changed. For the first time since this began, Weston Dynamics wasn't trying to defeat me anymore. They were trying to calculate how much the truth was going to cost them. By the time the settlement conference arrived on day 31, Weston Dynamics barely resembled the confident company that had marched into court a month earlier. Their legal team looked exhausted. Boxes of documents lined the walls outside the conference room, and every conversation seemed to happen in whispers instead of boardroom voices. I showed up wearing the same navy suit I'd worn during my final jury trial years before. It still fit surprisingly well. As I adjusted my tie in the hallway mirror, I caught myself laughing. 3 years earlier, I'd traded tailored suits for steel-toe boots because I thought I was leaving that part of my life behind forever. Turns out some parts of you never really disappear. They just wait quietly until they're needed again. The conference began with numbers, as these things usually do. Their attorney cleared his throat and presented a revised offer that was dramatically different from the one they'd waved in front of me 2 weeks earlier. $200,000 covering my retirement incentive, lost wages, and contractual damages. Then another $350,000 for emotional distress and attorney's fees, even though I'd represented myself. Total payment, $550,000, wired within 90 days. But the money wasn't what caught my attention. It was paragraph 7, public acknowledgement of wrongdoing before all company employees. I read that section twice before looking up. Whose idea was this? I asked. Their outside counsel answered honestly, not ours. My eyes drifted toward the far end of the table where the company's new interim chief executive sat quietly. Richard Holloway wasn't there. Neither was Melissa Grant. The interim CEO folded his hands together and said something I honestly wasn't expecting. Mr. Mercer, the board conducted an internal investigation after reviewing the discovery materials. Mr. Holloway's employment has been terminated effective immediately. Ms. Properin. Grant resigned yesterday morning. There wasn't any celebration inside me when I heard those words, just silence. I thought I would feel victorious. Instead, I mostly felt tired. Careers had ended. Reputations had collapsed. And all of it had started because someone believed the easiest way to increase quarterly profits was to take money from people they assumed couldn't fight back. I signed the settlement agreement after one final revision, making sure no future employee would be prevented from reporting similar conduct. 2 weeks later, I returned to the same building where I'd spent 3 years pushing a cleaning cart through polished hallways. Only this time, security greeted me by name before escorting me upstairs to the auditorium. Around 240 employees filled the seats. Some recognized me immediately. Lewis smiled from the third row. Nancy had somehow convinced someone to let her attend because she'd become invested in the whole story. I even spotted a few maintenance workers standing quietly near the back wall, still wearing their uniforms. The interim CEO stepped onto the stage first. He didn't rush through the statement or hide behind carefully crafted legal language. He admitted the company had failed, acknowledged that employees had been treated unfairly, and apologized directly to me in front of every person in that room. Then he walked down from the stage carrying a simple envelope. This belongs to you, he said. Inside rested the settlement check, $550,000. I looked at it for a second before slipping it back into the envelope. Oddly enough, the number wasn't the most valuable thing I'd received that morning. Respect was. Something they could have given me for free 3 years earlier. After the meeting ended, dozens of employees stopped me in the hallway. Some thanked me. Others quietly shared stories that sounded painfully familiar, promised promotions that vanished, overtime disputes that somehow always favored management. Retirement benefits explained one way until someone actually qualified for it. One older warehouse supervisor shook my hand and said, "You didn't just win your case. You made the rest of us realize we don't have to stay quiet." I don't think he'll ever know how much that meant to me. A month later, I officially declined an offer to return as outside counsel for Weston Dynamics. The irony wasn't lost on either of us, but going back would have felt like walking in circles. Instead, I opened a small consulting practice focused entirely on helping employees understand contracts before signing them, documenting workplace misconduct, and recognizing the difference between company policy and actual law. Most people don't need an expensive lawsuit. They simply need someone to explain what their rights really are before fear convinces them they don't have any. Every now and then I'll drive past that glass office tower on my way to meet a client. The dumpsters are still behind the loading dock. The maintenance crew still rolls the same blue trash carts through the service entrance every evening. Sometimes I wonder whether the new janitor notices conversations drifting out of conference rooms the way I used to. Maybe he does. Maybe nobody notices him either. If that's true, I hope the executives upstairs learned one lesson they'll never forget. The person quietly emptying your trash might be paying far closer attention than you ever imagined. And here's the question I've been thinking about ever since this all ended. If you discovered your employer had been quietly taking advantage of workers for years, would you settle once they finally offered enough money? Or would you keep fighting until every truth came out, no matter how uncomfortable it became for everyone involved? Let me know what you honestly think in the comments, because there isn't always one perfect answer. If you've ever been underestimated, judged by your job title instead of your character, or watched someone in power assume you couldn't fight back, share your story below. Read through someone else's experience too, because sometimes the strongest reminder that you're not alone comes from a stranger who's lived through the same thing. And if this story stayed with you, don't forget to like the video, subscribe, and I'll see you in the next one.